Hello, my name is Nathan Dennis, and today I wanted to make a video on how you could potentially get your Second Amendment rights back if you've ever lost your right to bear arms because of a hospital stay. So if that is you, then this is the right video for you. So before I say anything else, I'm not a lawyer, so please take everything I say with a grain of salt, but this is me giving you my interpretation of the research and the laws that I've looked up, and me talking to lawyers and this and that and reading case law on certain cases on how to get your rights back. So like I said, take everything I say with a grain of salt, but this is how I understand it to be. So yeah, so unfortunately for me, I lost my right to bear arms under state law and federal law. Now, there's two separate laws you have to worry about, and it's those two laws. Now, different states have different procedures and laws pertaining to being in a hospital, being committed. But generally speaking, most states follow what federal law says. And the federal statute that I want to refer to is 18 USC 922 G4. And that statute is basically a statute that says that if you've ever been committed to a mental institution or if you've been adjudicated as mentally defective, then under that statute, you are prohibited from having a gun forever, basically. And like I said before, most states usually follow that same language in their state laws. So, yeah, so basically, there's a way to get your rights back, really, and I'm going to really pertain to 17 states in the country because as it stands right now, if you don't know, there's a program called the ATF Federal Relief Program, which is basically a federal program that was passed in 2007 that allows you to file in state court to petition the state court to relieve your state and federal firearm rights back, basically. Basically, if you relieve it in state court, then simultaneously it will also relieve your federal rights too. But unfortunately, there's 17 states that don't qualify under that the regulations of the ATF Federal Relief Program, apparently under their state program. So the ATF doesn't recognize the program as sufficient enough to relieve the federal disability. And those 17 states are California, Colorado, Connecticut, Georgia, Maine, Michigan, Minnesota, Montana, New Hampshire, Ohio, Rhode Island, South Dakota, Vermont, Washington, Wyoming, Arkansas, and Mississippi. Now, I might have one or two wrong, particularly only because of the way the state law is written. It doesn't have much information on it, but based off of the ATF website that lists all the qualified states, those states aren't included in it, and it's updated. So if you live in those states, this video is more for you. Because in the other 33 states, all you have to do is you have to go to state court to prove that you're not a danger to yourself or other people, basically. So, yeah, so this is for the people in the 17 states. So what you have to do to get your rights back, and it's convoluted, and I apologize if I'm, like, rambling, and it might be hard to understand, but I'll try to explain it the best that I can. So basically, so how it works is that because those state programs don't qualify under the federal relief program, you won't be able to relieve your federal rights. And so, though you may be able to relieve it in state court, you'll still be barred federally. And to relieve that, you would have to file an injunction in federal court saying that the federal government is violating your Second Amendment rights, basically. You're not suing them for money, but you're suing them for a remedy, basically, which is, they're causing a harm to your, to your right to bear arms, basically. Basically, you'd be suing the FBI, ATF, and I'm sure a couple other directors of the federal government or whatever. But and this has been successful in multiple courts. And basically, you would, like I said, you'd have to you would have to argue a Second Amendment case as applied. not facial, if as applied challenge and not a facial challenge. An as applied challenge is basically you're saying that that specific statute that's being applied to you is unconstitutional to you particularly, as opposed to a facial challenge, which is saying that it's unconstitutional no matter what. You don't want to do that or you'll lose. Based off of the, I would say from my interpretation, the what Heller says and what Bruen reiterated what Heller said, and then this recent Rahimi case in the Supreme Court that just dropped last month, saying that, you know, if you pose a danger, then it's constitutional to bar somebody from having a firearm. And being mentally ill, or being that's somebody saying you're mentally ill at the hospital or whatever, you qualify under that statute. So it's not unconstitutional, at least facially, but as applied to you, it could be. I know this is convoluted language, but basically, okay, so you would file an injunction in federal court saying that the government is violating your rights, and from there, so the thing that's bad about these, like how like courts, they tend to have these court doctrines and shit where you can say certain things, or you could present this type of evidence or that evidence, or just some things that you can do and some things you can't do. And unfortunately, how it stands right now, the passage of time does not matter, or your rehabilitation from your disability from the government's perspective is not like a defense per se to the injunction, because what they would say is that you don't have Second Amendment rights, and that would be hard to prove otherwise. And what I mean by that is that when you're committed to a hospital, any of the 18 U.S.C. 922 G, that's the federal statute that has 8 categories, G1 through G9, whether it's a felony, a drug user, or an alien, mentally ill, whatever you want to call it. That's the statute for all 8. All 9. But basically, at least from Heller, which is the United States versus Heller decision in 2008, they said that particularly felons and the mentally ill do not have Second Amendment rights. Basically, they don't have that, and basically, when you're in that category of the G's, you lose your right. So you don't have a Second Amendment defense per se when it comes to the injunction or any lawsuit that you make. However, and it's also presumptively lawful. So basically, that regulatory aspect of it is like lawful without any question. But what you would do in an injunction is that what you would have to do, and this is the only way you can do it, because you don't have a Second Amendment defense, you don't have a case. And you can't make a 14th Amendment due process or equal protection clause, claim, because nor a Fifth Amendment claim. For the 14th Amendment, you can't make a claim because there has to be a Second Amendment violation for there to be a 14th Amendment violation. If there's no Second Amendment violation, then there's no 14th Amendment claim you can make. So what you would have to do is, in order to get your rights back, you would have to prove that you're safe to have a firearm, but it's literally impossible to prove that you're safe to have a firearm because you don't have a firearm. And so to get around that, you would have to work for a government job, basically. You would have to work as like a police officer or work in the military or any job that's governmental that would require you to have a firearm. And the reason why is because there's another federal statute, 18 U.S.C. 925 A1, which is an exception to the disability, which basically is that if you work for any department, agency thereof, whether it's local, state, or federal, then you're exempt from the disability from 922, any of the 922s, except for G9, but G1, G2, G3, G4, G5, G6, G7, G8, you're exempt from that, basically under federal law. And what you would be doing is that if you got a job working for the government that has firearms, then you're forcing, like in your case for the injunction, you're forcing the government to take into account your your government job, because when you do your as applied challenge, you would say it's unconstitutional as applied to you because you've demonstrated that you're able to possess a firearm because of your job, basically. Your job is giving you that opportunity to prove that, as you wouldn't be able to do that any other way if you tried to do it without having a firearm. Because it's like saying, like, for example, this is how hypocritical it is. It's like saying you can you're trying to get a driver's license, and like it's illegal to drive a car and it's illegal to get a driver's license. So there'll be no way for you to get your driver's license or drive a car, because the act of driving the car is illegal. You can't prove to the government that you're safe to drive a car because it is literally illegal to drive a car. So there's no other way to do it. But then they say, oh well, though it's illegal for you to drive your personal vehicle and get a driver's license for yourself. Basically, think of your driver's